Did you happen to get any confirmation on whether PD would make it, or anyone that would be representing the department?
I'm the highest in command.
Oh,
There's only PD oversight right now.
I see.
PD oversight really doesn't like to do
Of
that stuff.
Of course they don't.
One of them's pulling up though, I guess. See, one of them is.
Well,
Maybe.
if no one pulls up by the time we call the case,
Sure.
that's not going to look good.
No.
All right, bye-bye. My clients are pulling up, Your Honor.
Who's your client?
That'll be Cash and Danny.
Okay.
There
Can-
they are.
Okay, great. We'll see. Is that Mr. Seal I see over there?
That's Teal and Kevin, yes.
Okay. Mr. Seal and Kevin, would you kindly? Are you able to hear me?
Teal and Kevin, he wants you up there.
Officers, the honorable judge is asking for you.
Where do you want us?
I have a real quick question because I think that it's just in fitting that you be notified, at least, within a few minutes before starting, that the commissioner agreed with the attorney representing the plaintiff here to be here by 8 EST, 8 p.m. But I don't see him here, although he agreed to be here by that
It's
time.
got a few minutes.
Okay. Hopefully he
Ladies,
he
y'all
makes
gotta
it
step a
in.
little bit back, and y'all gonna be searching a minute, okay? Miss Officer.
Do you happen to know if he's anywhere within reach?
I'm about to reach out to him.
Hello?
Okay.
Yeah, you could perform a search on my two clients.
Got you.
Yeah, thank you.
Hello. I'm good. How?
Alright, I'm gonna be searching you. Please put your hands up. So.
Anybody here is a lawyer?
I am.
You, right? Correct.
He's good.
Okay. There's no search for you. She's up
Now,
there,
in the worst of case scenarios, he doesn't appear. Do you have a backup person designated for representing the?
It's pretty much me and Seal.
No.
Yeah, we're oversight.
Put in your car and then.
Okay. I mean, you can still represent the interests of the police department. Worst case scenario that I'm trying to get y'all a DA, an active one at least.
Yeah, you can take it.
I'll be
I'm a bailiff.
trying to get into that, Your Honor, but it's gonna happen after
I see.
our cases I have.
I see. Okay. So you're telling me that you're interested in the DA position?
Yeah.
Okay.
Who's interested in DA?
Because this gentleman here on blue.
Blue shirts?
Yes. Typically, you only have one DA and then multiple assistant DAs, district attorneys. All right. So it's exactly 8. Do you know if he's going to be able to make it or?
No, he will not be.
Okay.
He had some stuff come up.
Okay. So which one of you two would like, or both of you at the same time? It doesn't matter. I can add you to the, to the cases so that you can take a look, see the evidence and everything that's been submitted.
Sure.
Okay. So that'll be available to your Gmails.
Yeah, sure. What's it called?
That is the one that's upcoming now is Kane Holloway
Kane
versus.
Holloway PD.
Yes.
I bet.
Do you need a few minutes to check over everything? Or?
I mean, yeah, that'd be
Okay.
actually amazing.
All right. You can go ahead and do that. That's not an issue. Come pay. You mentioned you have clients here.
Yeah.
Are they clients or are they witnesses relating?
No, they are the one that filed
Okay,
the subpoena
gotcha.
that you were scheduled for today.
Okay, all right, gotcha. So then let's have them sit on the benches outside. Meanwhile, while I
Okay.
call out this case.
All right.
Thank you.
Ladies, can y'all sit in the back right out here?
And bailiff, everyone has been searched, right? Except law enforcement,
Whoever y'all choose
obviously.
is perfectly fine.
Okay,
Everyone's been searched.
thank you.
We have a court case going on.
All right, so to my left, if defense counsel with the client or their client, my left bench, that's your bench, and police department's bench is my right. If everyone could take your benches, I'm about to get the record started. Thank you. Again, the bench of the prosecutor is the right one. The defense is the left one, my left. All right. I understand this is a first for some of you. So I'll go over this. The defendant's bench. All right, so the plaintiff sits here.
Okay.
The
Sorry, Your Honor.
That's all right. The defendant's bench is this one. So PD, these chairs over here are yours. Where you're at is for the jury. Excellent, excellent.
Can we have these gentlemen searched?
Please.
Officer,
Yeah, I got you.
please. You mind if I stand here, Your Honor?
That's fine.
I need you to put your hands up. I need you to put your hands up.
All right.
I'm the bailiff. Yes. Alright, you're good.
PD, are you good on the reviewing of the evidence submitted, or do you need more time?
Sure.
Okay.
Yeah, fuck it. Sure. Good.
So, all right. The court is now calling case Kane Holloway versus Neon's Police Department. Do we have attorney present? Yes. Plaintiff is present. All right. The record is now on. If I can please have the plaintiff and the plaintiff's counsel state their full names for the record.
Elsie Gray. Lawyer.
You please have the plaintiff also state their names for the record.
Kane Holloway.
Thank you. Right, and representing the police department today is first name and last name, please. Okay. Representing the Neon Police Department, we have whom? Please state your full first and last.
Can you hear me?
Now I can.
All right, perfect. It's S1 Seal Diamond.
Thank you. All right. Is everyone ready to go? Everyone ready to start?
Yes, Your Honor.
Excellent. We'll begin with opening statements, and the floor is going to go to the plaintiff to provide an opening statement. Opening statements are not required. You can waive them, but they are formally part of the hearing. So,
Yes, Your Honor.
plaintiff, you have the floor.
Ladies and gentlemen of the jury, well, ladies and gentlemen, and Your Honor, today you will hear a story about rights, responsibility, and accountability. This case is not about questioning the importance of law enforcement. We all understand the vital role officers play in keeping our communities safe. This case is about what happens when the power is misused, when the safeguards that protect every citizen are ignored, and when an innocent person is wrongfully taken into custody without cause. My client, Mr. Holloway, was going about his life when officers of the Neon City Police Department arrested him without lawful justification. No warrant, no probable cause, no crime committed. What should have been an ordinary day turned into a nightmare for him. Handcuffs, humiliation, and the trauma of being treated as a criminal when he was not. The Constitution guarantees freedom from unlawful seizure. The law requires that arrest be supported by facts, not assumptions or hunches. In this case, those protections were disregarded. We will present evidence that the officers acted recklessly without proper investigation. You will hear testimony, see records, and learn how the police department failed to follow its own procedures. And when you've heard the full story, it will be clear that this was a false arrest, an abuse of authority that caused real harm to an innocent person. At the end of this trial, we will ask you to hold the police department accountable, not just for what happened to Mr. Holloway, but for the principle that no one, no matter their position, stands above the law. And for that, Your Honor, I yield. Thank you.
Thank you for providing the court with an opening statement. Next, the police department has exactly the same opportunity to provide an opening statement before proceeding. Again, opening statements can be waived if you so please. The floor is yours, PD.
Can you repeat that last part real quick? Also,
Yes,
Are you on shout?
I am.
Oh, interesting. All right, continue.
Anyone has food and drink by chance?
I do.
Oh,
Thank you.
perfect.
Yes, I was mentioning that opening statements are waivable. That means you don't have to provide
Come
the
closer
court.
to you, Your Honor.
That's fine. Come. You don't have to provide them, but they are formally part of the hearing.
Can you get on up, Your Honor?
If
Get down.
you'd like to waive providing the court with an opening statement, you may.
You got that?
Nah.
No.
We
Are
can
you-
waive it?
You'd like to waive. Okay.
Yes, Your Honor.
Can you come down? Yeah, come down. Okay. It's not allowing me.
Just drop it. Drop it on
So
the
yeah,
floor.
I'm gonna drop it on the floor.
Thank you. Appreciate you.
There you go.
There we go.
Got you a
Thanks.
drink.
Yeah.
I'll give you a drink.
Thank you.
Right there. There you go.
Appreciate it. Thank you.
No problem.
Right. Pardon me for that. All right. The police department waives providing the court with an opening statement. Just perfectly fine. Now, plaintiff or counsel, you're aware that evidence is the only thing that is upheld in this court. You are now in complete access to provide or utilize the evidence that's already been submitted, all the exhibits of footage, testimony, and anything else within those articles you can utilize. You now have the floor to showcase the specific circumstances surrounding what has led us here today. Without further ado, please. Counsel.
I apologize, Your Honor.
It's okay.
Needed a cough drop. Yes, thank you. On the
Unable to hear you.
violence in court, thank you.
Oh, is someone speaking?
Yes, behind me, Your Honor.
Bailiff, you,
Alright.
you kindly remind the audience that they are to remain silent, please.
Thank you, Your Honor.
So
I was saying, on the late hours of Monday, September 15, 2025, my client, Mr. Holloway, was working at the oil rig in Toledo when officers Diamond and James was patrolling. He was properly parked his car at the right parking spot and was heading towards his car to leave the area. When both police officers pulled up on him and was not able to search him, they probably had probable cause to search him, but no evidence was found that he was selling controlled substance. They failed to read his Miranda rights upon his arrest and improperly towed his car when it's properly parked on the side of the road. Again, there was no evidence presented to the court that a controlled substance was found with him and in his vehicle. In addition, when I came to PD, Officer Lucas Hubley let me in to PD and disclosed that he was not one of the arresting officers, even though the evidence presented to the court shows that he is one of the arresting officers and actually transported Mr. Holloway to PD.
And this is in the exhibits that you've submitted to the court's evidence. Okay. So, I'm sorry. So, is there a claim now then being made that PD has conspired or lied to a DOJ attorney with end result hidden objective?
Correct, Your Honor.
That's the claim you make.
Yes.
Okay.
Is the negligence that my client, Mr. Holloway, was falsely arrested.
Okay. Your client was ultimately charged with what exactly?
He was charged with selling controlled substance.
Although no substance was evident to be in him.
Correct.
All right. Please do proceed.
Due to this negligence, My client offered significant lost wages. He holds 4 jobs in the city as a captain at Bullet Armory, apprentice at Auto Exotic, employee at Bean Machine in Wheatland. Holding those 4 jobs and being held in a jail cell for 25 months caused significant loss in his wages. In addition, my client suffered emotional distress because he was put in jail and solitary confinement, as well as physical harm from other inmates. Therefore, my client is suing Leon Police Department for $200,000 due to this negligence.
Are you resting at this time?
Yes, Your Honor, I yield.
Thank you. A follow-up question to the sustained damages as a direct result of the imprisonment of your client.
Yes,
Amongst those claims made, the first one was being charged criminally with a drug charge when no solidified means of evidence to justify the arrest and subsequent charging and remanding to the custody of the Department of Corrections to serve an imprisonment term unjustified. Is this your claim?
correct, Your Honor. In addition, he was charged a $25,000 fine for his arrest and removed getting his car from the impound, which he had paid for.
And do you happen to know exactly the amount that was paid in order to secure the vehicle to his return?
According to my client and from EA Durian Sonome, it's $7,500.
Thank you. It was my understanding that the district attorney commissioner would be representing this case. Do you happen to have any information to provide the court as to why he fails to make an appearance, counsel?
I don't know his whereabouts, Your Honor.
You do not? Okay.
No.
He did agree, however, to be here today.
He did, and that is in writing.
Okay. Thank you.
You're welcome.
All right. PD,
You're
these claims that are being made against your department for the alleged sustained damages upon the citizen. It is now your opportunity to defend the integrity of your department. It is now the opportunity for you to defend what the force that's supposed to protect and defend with any means that you find justifiable. The floor is yours.
Yeah, so basically she's claiming that we didn't read them their rights or whatever upon arrest, but we're allowed to read them their rights as long as we don't search them or process them first. So we did read them their rights. Also the claim against the officer not being an arresting officer or whatever, technically he wasn't. He was just a transport and a processing officer. So technically he's not the full officer that actually placed the person under arrest. So that bullshit's just bullshit.
No. That language cannot be utilized here.
Alrighty, my bad. That's just a bunch of BS. And then what else was it? Oh, also, yeah, the suspect didn't have any drugs on him or anything. or was making a sale or whatever it might be. That's not the case. I'm not sure why necessarily it wasn't brought up, but there is clear evidence that we were patrolling the area before we placed the suspect under arrest, and we have clear evidence of the suspect doing multiple pill bottle handoffs. So,
Okay. And that evidence to which you claim having, is this evidence something that has been provided to the court?
negative. That's why I said I'm not sure why they get brought up when this was getting sorted.
That's a very good question. The discovery phase has ended unless motion is sought after for an extension. This court has not received any evidence whatsoever from the department.
Yeah, I'm not entirely sure. Like I said, I wasn't. This was kind of just like
Right.
last second.
I
So I don't know
completely understand your stance. 100% because you're correct. However, plenty of time was issued so that all requirements of the court and the requirements of law were met. However, even with the sufficiency of timing provided, PD failed to carry out the required elements that are necessary for a court case. Although that cannot be used against you because it was not you who was representing the department then, it will ultimately impact the decision of this case, the outcome most definitely, unless you would be able to provide that submission now.
Yeah, sure.
Okay. Now I can't stop anyone from making objections. Counsels and each party can make objections at any point during this hearing. So if there is something that you disagree with, rather, you're welcome to make.
Objection, Your Honor.
What's the basis?
It's hearsay. So, again, when I arrive at PD to meet my client, Officer Hubley let me in PD, and he cited, and this is part of the evidence that was provided to the court, he cited that the arresting officers were Officer James, Diamond, and Drippington. He did not identify himself as one of the arresting officers. And from my perspective, if you transported the perpetrator, you are one of the arresting officer, because it is also evident, again, the evidence that was submitted to the court, he read his Miranda rights. Officer Hubley presented or read the Miranda rights for Mr. Holloway.
And counsel, is there evidence in the exhibits you've submitted? Is that
yes, I believe it's in exhibit C or D.
okay? The officer that recites Miranda rights upon a detention or arrest, depending on the circumstances, may be considered the arresting officer. It is the arresting officer's responsibility, unless otherwise delegated or requested by the original officer, to make that determination because of their inability to do so at that time. So your initial objection, for clarification's sake, is that hearsay. Is that correct? I can't hear you. Still can't hear you. Can anyone hear her?
Negative.
Counsel? Are you still with us? Okay. I need to fix your voice box, and while you do that, PD, do you have any objections?
Yeah, I have an objection. That's hearsay as well. She said one of the arresting officers were Drip or something. That officer wasn't even on duty at the time of the arrest, I believe. So yeah, so I don't know where she pulled that name from, but
Drip?
I believe the only officers on duty at the time were Kevin James, Phil Diamond, and Lucas Hubley.
Okay.
And again, Your Honor, sorry.
Mm-hmm.
I'm not saying that Officer Drippington is one of the arresting officers. Officer Hubley stated that he was one of the arresting officers.
Okay. And there is...
Again, that evidence was provided to the court.
Okay. So then, PD, how can you claim that the individual was not the arresting officer when the evidence clearly outlines otherwise?
Who? Lucas or Drip?
Did you mention the name Drip, counsel, as one of the arresting officers?
Yeah, she did.
I did.
You did.
Because it was provided by Officer Hubley.
Right, but we have determined that the statement from Officer Hubley could have been dishonest.
Correct.
Okay, and that statement is also witnessed in the footage that was provided.
Correct. Exhibit C or B. Exhibit C or D.
Thank you. Let the record reflect that Officer Lucas Hubley attempted to, whether it be knowingly or by accident, make false claims to a bar licensed attorney. Now that will require additional investigation, but under different circumstances.
Another objection, Your Honor, for lack of foundation.
On which?
From the statement from Officer Diamond here. He mentioned earlier about the fact that...
Can't hear you.
Hold on one second, I'm reviewing my notes.
Gotcha.
He mentioned that the subpoena was not provided to PD, whereas a subpoena was provided to District Attorney Sonomi on September 18th. And again, another subpoena was sent to him on September 22nd.
I'm sorry. Okay, hold on. When did he make that statement?
Yeah, I want to object that. I didn't say that at all.
So what I'm saying is that this court should not accept further evidence from...
I see what you're referring to. Okay.
Because the fact of the matter is, submitting evidence has already lapsed.
I understand. The objection. Officer Seal, are there any extraordinary circumstances that would have this court incline reopening a phase of the judicial process once it has already expired, that you can make for this court to be inclined to accept any additional submissions? For example, something happened to the commissioner Durian by chance, or any mitigating circumstances that would justify or not?
No, but
Okay.
if a subpoena was submitted for our body cams, why weren't we given the subpoena?
That's a
Or are the
very
subpoenas being directed to one person? Because say
that's
that
a
person does take ill or something happens to them,
Mm.
that's just not allowing us to
Mm.
be aware that we need to submit more.
I agree. I absolutely agree. We do our very best to ensure that PD has plenty representation. Up to my knowledge, there's multiple district attorneys available at the police department, even the lead DA as well. I believe there's no excuse there. That was actually the request for subpoena wasn't only made there in that ticket in mails, but rather also verbally. Why it wasn't done, that's something that requires further investigation. And although I understand your stance, I unfortunately will have to, or fortunately, for lack of better terms, take it or leave it. I'll have to sustain the objection since sufficiency was there. If PD did not ensure that securing or properly abiding by the court order and a failure on their end, sometimes it is what it is.
And Your Honor, if I may, it is the district attorney's responsibility,
It
regardless of
is.
how many they are,
It
to
is.
provide evidence to the court regarding to this case.
It is. That's why it's being sustained. I mean, I did in fact give multiple notices, and I made sure that that was announced. But ultimately, I can't force anyone to do something that they don't want to do. Moving forward, however, I believe there's additional people interested in the office of the district attorney, so that should fix the problem moving forward. Any further objections from either side?
Negative, Your Honor.
Okay. Anyone has anything additional to add materialistically to the case?
Oh, Your Honor.
Very well. Plaintiff counsel, are you waiving closing statements or are you providing?
We are waiving closing statement, Your Honor.
PD, are you providing the court with a closing statement or are you waiving?
Nah, I mean, the only clothing statement I would just say would be, I think it's dumb that subpoenas are being filed and only sent to one person, or and not being directly submitted to the exact person that the subpoena's being filed upon. So if I get filed a subpoena against me, I should be given it directly. Therefore, I know exactly what needs to happen. And then, as far as the other stuff goes, yeah, the lawyer here says that yeah, no, Drip was one of the arresting officers because Lucas might have provided a misinformation. But again, like I said, Lucas wasn't on scene. He was a transporting officer and a what's it called? A processing officer, so he didn't fully know what happened on scene when we placed the suspect under arrest. So, in the evidence that was provided to the court, it clearly shows when me and Mr. James show up in cells, we clear it all up, saying exactly what's
Right.
what the information was of who the
Right.
arresting officers were, what happened, etc., etc.
Sure. So eventually, by the end, every confusion was clarified, at least in terms of that. Is that what you're stating?
Yes, Your Honor.
Okay. Any additional information by the plaintiff after hearing this, or you continue to waive and proceed to sentencing?
Again, we want to uh, we want to hold them accountable for false arrest, Your Honor, because no evidence was submitted to court regarding or proving that my client, Mr. Holloway,
Right.
was selling controlled substance.
Okay. I understand. I understand your statement. Question
Let's
is,
not stray away from that, because that is what the matter of the court today.
right. Right. As the presiding judge over this case, and having followed from initial submission to present, I've reviewed all evidence submitted and have noted the lack of submission. A subpoena is a court order. It is not a suggestion. It is not a request. It is a direct order. The police department is tasked with a very, very difficult task, which is to protect, serve. That includes the rights and liberties and property of each citizen. But it's also tasked with a very important task, which is to ensure that the law prevails, and reminding everyone that no one is above the law. If you break the law will apply to you equally, regardless of who you are. That remains true with the following decision. I am going to now provide a rationale for the judgment that this court will pass. And this rationale is as follows. The court has one function. Amongst those functions, the most important function is to ensure equal access to law. That means that a poor individual will have the same access to the legal system as that of a multimillionaire. That the court does not see distinctions among. And two, that the decision that is reached today is based upon the rule of law. Submission of evidence. And although it is very clear for me that people's failure to perform or lack of energy or lack of dedication isn't an excuse to not fulfill a judicial order. If the court issued an order and that order was acknowledged by both parties, there is no excuse. The duty of the district attorney would be then to contact the parties involved that are within the police department and inquire. That is why he serves the Department of Justice. The district attorney is employed by the Department of Justice. It's clear here that further investigation be required, and if no justifiable excuse is found, the Department of Justice will have to release that district attorney from his functions. It's a very important duty. And if it cannot be fulfilled accordingly, then a willing and just capable individual is then found to replace the one that is unable or incapable. In this court, and in this case, the plaintiff is seeking $200,000 worth of restitution. Does this court find that this sum of restitution is just and fair? Is it justified through the claims? Is it justified through evidenced incurred damages? No, not exactly to that amount. The rationale I provide further elaborates why. I understand that you incurred $25,000 arising out of this arrest, the fines that you were charged, and additionally $7,500 for the return of your vehicle from impound. These are evidenced charges that can be evidenced and make sense. But apart from that, wages lost. The court has not received any evidence of wages lost, and unfortunately has to dismiss that portion of restitution on the grounds of insufficiency of evidence. The next claim made was emotional distress, and whereas it may be true, emotional distress usually requires the diagnosis of a physician or a medical evaluation to justify an evidence that such distress or emotional damage of any sorts happened. However, a restitution amount for that claim can still be made to a limited basis, followed by the last point. The court has to remain unbiased and only be led to decision making through evidence and evidence alone. And that is, the court has not received any evidence whatsoever that the individual was found in possession of any illegal substance. The court will completely expunge his record free of charge for that alleged offense, as no evidence is justified through any submission. And whereas it may very well be so that the police department is in fact in possession of material evidence, it was not submitted in a timely fashion to the court. And lastly, yes, this court is bound to make a judgment in favor of the plaintiff, not in $200,000, but in $150,000 to be compensated for restitution and payable immediately, either to the attorney or to the attorney's client in said amount. This is the order of the court. This matter is closed. Thank you, ladies and gentlemen. I believe there are pending additional matters before the court. At this time, the associated attorney with that case will proceed to take over and call their clients.
Thank you, Your Honor.
Thank you.
Thank you. I'm good. I'm done.
Have to have a seat on there. On here. On here. Y'all can both have a seat there.
Counsel, the matter that you have pending is also against PD, correct?
Yes.
Okay. And let's see.
That will be against Officer Phoenix and Officer. Double check that. I don't wanna say the wrong name.
Do you have a case number by chance?
0902.
0902. I see it.
That'll be Officer Harago and Officer Phoenix.
Okay. I do see that I signed a subpoena for that body cam footage, and the court will ask if you have complied with due service for that subpoena.
Not at the moment, Your Honor. I did not get the chance to get to PD.
Okay. So, just so that we can move properly to the next stage, are you planning on seeking for damages, restitution, or
damages against my clients?
okay. That would be that would be according to record Danny Frost and Casper.
Yes, correct.
Okay. And you're suing the officers individually, or are you suing the department?
I'm suing the officers individually.
Individually, okay. And what was the officer's name again?
1 second, Your Honor.
Sure.
The Officer Phoenix and Arago.
Phoenix and who?
And Arago. Sarit Arago.
Spell that for me.
Sarit would be Z-A-R-I-T. Last name would be H-A-R-A-G-O.
Arago, okay. Sarat Arago, is that correct?
Mm-hmm.
Okay. So here's the next step. Due process is required for that subpoena. Go ahead and tag district attorney, lead district attorney, and commissioner. Right on it so that they can get notified. And the next stage would be for you to head over on to the police department and personally deliver it, either by hand and getting confirmation that they are in receipt of that subpoena. You have a completely legal subpoena there. That's an order for furnishing of body cam. Immediately upon the receipt of that subpoena by the department, but in this case, actually, it's the officers individually. So you will have to get a hold of them personally and hand it to them personally. Only then can we proceed to formal charges.
All right, Your Honor.
All right. So you have the next steps to follow. Do you or any of your clients have any questions that like to be addressed by the court now?
Do you guys have any questions? Yep. You can voice your questions now.
I can't hear you.
Me,
Oh, there we go. I can hear.
can you hear me, sir?
Yeah, now I can.
Can you
Yes.
hear me, Your Honor?
Yes, I can hear you.
Okay, thank you. All right, my name is Kashpad. I used to be an ex-PD for our Neon Police Department.
Okay.
I would like to officially say, for raw question would be, Your Honor, do we or do we not discharge a firearm at a citizen with their hands cuffed behind their back?
You do not, for they are defenseless and in your custody.
I agree, thank you. And do we or do we not tase or deploy a non-lethal shotgun, which is a beanbag shotgun, at a citizen that has their hands behind their back cuffed?
No, that's police brutality.
That is police brutality. Thank you. That would be my questions for today, mainly because of that. And also, my main other question would be, within demands of how we portray things, right? We do go over demands properly, and when obviously police do not go over the demands properly, and they end up going their way with things, not basically abiding by us or given respect, things can be apprehended a little bit more unlawfully, right?
That seems like a fair statement, yes.
Okay. My lawyer will definitely be able to give our statement today from obviously the raw footage that we have both provided, and kind of apprehend it from there, Your Honor. Thank you.
For sure. That is why I believe the footage is being subpoenaed to the court, so that all allegations surrounding the case can be evidenced. Then, based upon the facts of that evidence, we can proceed forward.
May I, Your Honor?
Yeah.
The commissioner did answer, and the request was already made for the body cams.
He did. When did he respond?
Just now.
Oh. I see. Okay. Okay, so he has already made the request for that footage. Now, how many days have elapsed? Original request was made just, actually, not even 24 hours ago. Very good. So then they have a limited time frame to supply the footage. If the court doesn't receive footage by then, those allegations will simply have to, by default, assumed to be true.
And may I, Your Honor?
Just a sec. Just a sec. Who wants to speak?
Officer Phoenix.
Oh,
he's here.
Oh, you're here, sir.
I am indeed.
Okay. You have the right to be represented by counsel today, unless you
Representing myself for today.
Are you certain? If you're certain, are you certain?
Yeah, I am certain.
Okay, very well. Then,
Officer Phoenix.
Yes, sir.
How can I go ahead and email you the subpoena? Because I was trying to reach you in the DOJ mails, but I cannot find you or your partner.
the commissioner has already contacted him,
Oh, that's fine. All right, that works.
and he has requested that said footage be furnished. Am I mistaken? Officer Phoenix?
Sorry about that.
No.
I was a little quiet. I've already submitted my body cams to our higher ups,
Mhm.
and it is being reviewed and will be submitted as soon as possible.
Okay. So the subpoena was issued. I understand that you'd like the footage to first go through a higher up.
That's our process, yes, Your Honor.
I mean, that's perfectly fine, so long as the furnishing of that footage is issued by the deadline within that subpoena. That's perfectly fine. Counsel, there is a deadline on that subpoena I signed, or no?
Yes, it is, Your Honor.
Would you
So
kindly?
that will be Thursday 20. Wait,
Uh,
that that'll be the 27th. Saturday the 27th at
okay,
5 a.m.
so that's coming up. Okay, all right. Ooh, 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 ooh.
Correct.
Ooh. Okay. Officer Phoenix, you wanted to address the court?
Truthfully, Your Honor, I don't really have much to say. I felt that this incident was pretty by the book on my part of things.
Okay.
I don't think that I had any wrongdoing in this
Okay.
specific situation. I'm not saying that it was perfect, but definitely do not feel that I am guilty of any crimes of any sort in this
Oh.
specific situation.
Okay.
If
I
may,
mean,
Your Honor.
the evidence speaks for itself at the end of the day. So
Exactly.
no one can question that because that's evidence. Yes.
If I may, Your Honor,
Mhm.
the officers at the time uh, didn't act in the manner that it should have been
So
handled in the
so
situation.
so I can't allow speculation to continue until that evidence has been submitted to the court. I
On my end, I did submit some footage from
oh
the dash cam of the
okay.
two clients, or my two clients.
I
Uh,
oh you're right. I do see that. Yes.
yeah. So
Okay.
whenever you want to look over that and
Yeah, this is
see what
new.
I'm really talking about,
This is new.
and I would explain that the officers did not act in the way or the manner that PD should be held upon, and that is the reason why my clients are suing for the amount of 200K each,
Oh,
plus lawyers' fees,
okay.
will be a total of 250,000 for each of my clients.
So that's 500,000 in total.
Yes, correct.
Okay. Okay. Um, I'll review the footage. This is preliminary. We're not here to discuss the outcome of anything. The court is satisfied, however, to know that the subpoena has been duly served, that every party directly associated or involved within this case is fully informed, and the only thing I have to ask would be if Officer Phoenix would like to be added to that court case in Mayhills.
Sure, Your Honor.
I
So
was
that
trying to, but I couldn't find him.
I did put a dot in your DOJ chat there.
okay. Let's see. In general?
Yes, Your Honor.
Okay, I see. Okay, is that Khalil Phoenix?
Yes, Your Honor.
Oh, you have not received your police rules here. Okay, you should have them now.
Thank you, Your Honor.
All right. Go ahead and counsel if you can add him.
I'm trying to find where did he tag or where did he put the
Yeah, no, or I can do it. That's fine. What was 0902?
yeah.
Okay. All right. Let me do this then.
Innocent.
Idiot. All right. So you.
Your Honor, if I may add, I was not aware that there was a third officer involved. Um, that is kind of newsome to me because when I went initially at the police station and I answered the call for a lawyer, um, the third officer was not present.
Okay. And is there evidence of the identity of this mysterious officer?
I'm not sure.
Yes, there is.
There is.
There is.
Okay. Um. And is that person pertinent to this matter to also be included or not?
She actually took actions against my clients.
Actions.
Or yeah, she actually did.
What
If
actions?
you want, Your Honor, I can ask for her to come down to the courthouse if you'd like.
Sure. I mean, if she's a party to the suit, she should have the right
I
to.
don't know if she's part of the suit at the
I
moment.
never added her because I
Oh,
wasn't aware of her until now.
uh, ask your clients before you move forward.
Yeah.
Alright.
So it's gonna be Officer Maria Sanchez
Oh,
deployed a beanbag shotgun on my partner at the time when they were cuffed.
she's been placed under investigation, and
One sec, Your Honor.
she's potentially looking at being permanently removed from the police department as a result of this incident. I didn't know that's what that was, but yes. Um, she was the bailiff here just not that long
I
ago.
did not know that was her name.
That's her.
The situation that transpired, Your Honor, was
Mm.
that my clients were not imminent threat at the
I
time,
think you
and
should
they
bring
were
her to bed.
shot at instead of being used non-lethal force or uh, being demanded for uh, for apprehension.
There he is. Okay.
Sorry
So
about that, Your Honor.
that's
I
all right.
have requested the other officer to attend the courthouse.
Okay. Can you confirm that you have received access to the case in mails?
Give me 1 second. And where would I see that, Your Honor?
That should be under cases.
Under the DOJ there?
Yeah, that'll be case 0902.
You don't see a ticket with that name on?
Yeah, I do see the ticket now, yes.
Okay.
Is this where I would submit my body cam footage, Your Honor?
Correct.
Correct.
This will actually outline the entire process until it reaches the court to a hearing or trial. If the officer has been served the subpoena. Would you update the record to reflect under that ticket that the subpoena has been acknowledged and that footage is being reviewed prior to submission, or provide an update of some sort? Would you? What's the name of the plaintiff again?
Cal Phoenix or Calo Phoenix.
Okay. All right. So again, what are we waiting for currently? Maria, or
If you need her, Your Honor.
do
If not, we can go forward and she can submit her stuff as well.
okay? Counsel, do you need? Is there? Do you need to serve her with subpoena, or are you requesting footage? What are you doing? Counsel.
Add her into the subpoena
Okay,
and also serve her with it.
go ahead.
Maria? Maria? Yeah, I'm gonna be tagging you on a subpoena for your body cam on the incident that entail with my two clients. Can you go ahead and write in the DOJ general chat and I don't know, whatever you want, a dot or whatever, so I could tag you into it. I well, basically.